So without further ado, I'm going to turn it over to our esteemed panel here to tell us a little bit about some of the challenges that we faced in the Wild West today and how they're thinking about the next generation of privacy legislation to bring it all back together into something that might be a little more sane. Over to you, Marty and Barb.
All right, thank you. Good morning, good afternoon, everyone. If we could go ahead and start the slides. Where we wanted to go is to, if we go to the next page, please, is first just highlight a little about what the Information Accountability Foundation is. And the main thing that we want the audience to take away here is that we are a think tank, we are a nonprofit, we work with our members in collaborative research and scholarship, looking for accountability-based solutions. And accountability, we'll talk more about that, but really means responsible and answerable. And we have some important foundational beliefs around the fact that organizations should be able to think and engage in knowledge discovery. As part of a trusted digital ecosystem, we believe organizations should and must be accountable, responsible and answerable. And we also believe that frameworks based on risk assessment and information governance enable both beneficial data-driven innovation while protecting individuals. So the next page, we give you just a little bit of an overview of what we're going to talk about. So we're going to talk about an information accountability framework as a model for US privacy legislation, underpinned with the idea that data should serve people and not create a bureaucratic mess. We'll talk about fair processing principles. So these are not the FIPS, but these are fair processing principles based on accountability and how that approaches risk and helps to minimize or at least manage it from a risk-based perspective. And a little bit about what implementing a risk-based, accountability-based legislation looks like, and a little bit of the highlights of that and why we think it's a better and different model. One other note is that the IAF is not a lobbying organization. We do not lobby. We are an educational organization, and when you hear more about our approach to model legislation, risk-based, our approach is really to reach out to and hold stakeholder meetings with a number of groups to educate on this particular framework. So with that in mind, next what I want to do is turn over to Marty so he can talk a little bit about, so what's the problem we're trying to solve, and then why do we think accountability and risk-based approach is the answer? Marty.
Well, thank you very much. Could you change the slide, please? So 20 years ago, Professor Fred Kate, who many of you know at Indiana University, and I wrote a paper. And we said that comprehensive privacy legislation in the United States is inevitable, and that the business community needed that to move forward with the digital environments that would be evolving in the United States. And Fred and I have prognosticated lots of things over the years, but we were dead wrong about the fact that it was inevitable and it was on the horizon. The fact is that there was deep dissatisfaction with the way we managed privacy in the United States and its lack of linkage to other places in the world, and that hasn't faded over time. There's a consensus that what exists here is just not adequate for the types of business models that are evolving. But that consensus is not just here in the United States. There is a paper that was issued a few weeks ago in Europe by the shadow rapporteur to the EU Parliament on data protection and AI. And it's a long paper that essentially says that the GDPR in its current form is just not adequate for the environment, digital environments that is evolving in Europe. And we see that in Canada, where there is draft privacy legislation, and people tend to think that the Canadian law has worked very well. Well, the draft law there has been tabled, and in essence been tabled because of deep dissatisfaction with the model. The fact is that that the current GDPR makes knowledge creation, this ability to use information to come up with new insights, almost impossible. Even though it's supposed to be based on a number of legal bases, it always comes back to this question of individuals should be in control of their data, even if they have no ability to do it. The law begins, in essence, discounts the beneficial impacts of data to individuals and it focuses on the probability that people won't be able to exercise the procedural rights. The law claims to be risk-based, but we're not sure what risks it's trying to deal with. And as all of you know, you've created a mountain of documentation since the GDPR went into effect and other laws. And it almost seems like that documentation exists purely for the purpose of creating documentation. Please change the slide. So as we begin to think about what a privacy model should look like in the United States, it's really useful to revisit what we learned in 2016. So as you know, in 2016, the GDPR was passed. The GDPR was enacted. It was really, settled in granite about 2015, and the world has changed in greatly since that law was passed. And the most important thing about the GDPR is it was advertised as being risk-based. But one of the important things about this concept of risk-based is this question of risks to what? And there was a huge disconnect between what the regulatory community in Europe thought the risks were and what business leaders who are trying to use data really thought. So the fact is that to the regulators, it was things like impediments to the individual's ability to exercise their rights, unfair outcomes from the processing of data. But they never really came to the grips with whether reticence risk was what should be addressed in privacy legislation. The absence of any discussion on what we meant by risk-based created disappointment in terms of how the law was implemented. So, for example, legitimate interest, which was supposed to be a very broad use of data and begin to facilitate productive, fair uses of data, has been really unused in Europe as a legal basis because it's so hard to do so, and there's a disagreement in terms of the risks that are managed in terms of this concept of legitimate interest. So the GDPR has turned out to be risk-based, but really risk-based on this question of individuals' ability to exercise their procedural rights. Please change the slide. And as we've gone into 2 years of dealing with a pandemic and the things that come out of the pandemic, we began to understand more things about what we really want in data protection law. So the pandemic has taught us that there needs to be this ability to balance the risks to individuals of their data being used against other risks that they have as individuals with broader societal risks. So the question of an individual having been exposed to the coronavirus, or having had a vaccination for it, and the interest of others related to that data became a deeply difficult issue for the regulatory community to deal with, and even businesses. At the same time, we've seen this concept of vendor oversight becoming an infinite loop of more vendors, more issues, more review of that, and it's become almost a business line of itself in terms of understanding who your vendors are, what their liability is, and what their risks to others are. As we've looked at the draft legislation around the world on AI, we begin to see that there's a disconnect between this nature of AI as always profiling versus the hostility to profiling that we see in the law. And this came out in the last year. We live in a world where observational ecosystems are just morphing. You think about the smart devices in your house, and we've been wrestling with this question of what is achievable governance related to this digital governance. And a great example to me, the best example, is the whole question of HR data and Schrems 2. I don't think there's an organization on this call who has employees in Europe and needs to bring that data back home who hasn't wrestled with this question of how do I bring that data back to the United States, which is never going to be subject to bulk collection of data in the regulatory environment that was created after Schrems 2. And we have some answers today, but this has been an issue that the IAF has used as an example. So the fact is that the chaos around data use has just morphed over the last few years. And to me, as we look at the AI proposed regulation in Europe, we see a disconnect completely between this AI structure and the fact that first you have to clear the GDPR before you can do AI. Please change the slide. So when we think about what is the public agenda for privacy legislation, we can look at the legislation that's come out of Colorado, it's come out of Virginia, come out of California, but we can also look at the draft legislation in Canada and the proposed discussion of legislation, for example, in Ontario, and the model bills that are coming out from various members of Congress. They all want to double down on the sense that individuals should be able to control their data in an information age. Well, the data flows are so robust that that's really not what one can do. So this concept of individual control, while incredibly politically attractive, is not very effective. We want to also at the same time prevent discrimination against individuals or protected classes, and we build that into the AI legislation, not into the privacy legislation. Are we looking in public policy to change profiling-based attention gathering business models, or are we just going to live with them? Are we really looking to set the boundaries for what are permissible uses of data or impermissible uses? Permissible uses of data are whitelist, impermissible, or blacklist. Can we really begin to anticipate what they're going to be? And are we going to try to differentiate the rules based on the type of business you are? Or are we looking for a common set of rules that can go for all types of systems? Please change the slide. So what would you, as a business leader, want from privacy legislation? At the IAF, we've asked this question of our board. And at our annual retreat, we asked that question of our members. What do you really want as a business leader from privacy legislation? And this really informed the poll that was asked up front. Do you as an organization want legal certainty? Or do you want the flexibility to use data robustly, but in a fair way? If I'm a general counsel, maybe I want legal certainty. But if I'm a data scientist, I think I probably want flexibility. And you can't really have both legal certainty and flexibility in the legal system. So what is your objective there? Are you a business where public trust is most important? If that's the case, you want something different in legislation. You want something that is very buttoned down so that you can enhance trust with your customer base. Or are you a business-to-business company and public trust is less important to what you do? Are you really want legislation to get you out of this bind of operational burdens from inconsistent state legislation? And we really haven't seen that yet. But look at the requirements in Virginia and the requirements in Colorado to do a risk analysis. None of those legislation, neither of that legislation define what they mean by risk analysis. And are you comfortable that the AG in Virginia and the AG in Colorado are going to come up with the same standard of what it means to do an adequate risk assessment? And what happens if you add Nebraska and Florida and Texas to that mix? Is this burden going to increase for you? And do you want federal legislation to sort of take that burden off of your lap? Do you want US privacy law to align with global standards? And if you do, which global standards do you want them to align to? It's easy to say we want them to align to the GDPR, but as said before, the GDPR is having real difficulty dealing with this concept of being able to use knowledge creation in data and even do research and even begin to do product development when you're using sensitive data. So is that the model that we want? Or do we want to align to a Singapore model? Well, my guess is Singapore is a country of 5 million people, does not have lots of clout with other places. So that's probably not what we mean. So do we really want US legislation to align with global standards, or do we want to find a way to make it interoperable? Do we want the legislation to truly allow us to fairly and without discrimination have rules that make advanced analytics and AI truly possible? Every business leader in the United States says we're going to be more AI driven. It's hard to see how you can be driven with the type of legal structures around privacy that are control based. I can't really get effective consent for my ability to think with data. So as a business leader, it's really important for all of us to think about what is it that we want with legislation. I think there's little pieces of each of this, but in the end of the day, this ability to think with data, to be innovative with data, is incredibly important to a digital future. Please change the slide. So at the Information Accountability Foundation, about 4 years ago, we put together a set of principles related to accountability for what we would like in legislation. And it was about 3 pages long. It was an excellent document. I'll say it's excellent because I was the lead author on it, and I take some pride in what we put in that principles. With those principles, we took it to Washington, D.C., and folks said, no, we're not interested in principles, we're interested in legislative language. So working with Mark Groman, who's been writing legislation since probably he was in 12th grade, joined us to author privacy legislation. And it's on our website. It's called the Fair and Open Use Act. And we truly endeavored to make the Fair and Open Use Act risk-centered and based on fair data processing. And by risk center, we're talking about the concept of and I want to get this completely right, adverse processing impact to individuals. So it's not based on collection. It's not based on any particular definition of personal data. It's based on this concept that we're going to create legislation that, in being risk-based, looks at this concept of adverse processing impact. And when we think about adverse processing impact, that's both harms to individuals that come from the use of data, but also harms to individuals that come from the choice not to use data. So think about the transfers of employee data to the United States from Europe. One, there is the risk that there will be bulk collection of that data by the government, but that risk is incredibly low. But there's also the risk that if that data isn't transferred, that those European employees will be treated in an unfair fashion, will not get adequate bonuses, will not get promoted, will not be considered for new opportunities because of the lack of flow of data. So when we say adverse processing impact, it's both the reticence risk that comes from not using data, as well as the explicit risks that are related to using data. And those are things that you can begin to measure. And when we think about this not just in terms of the organization and the individual, we think about groups of individuals and society as a whole, and the interest of the stakeholder beyond the interest in individual autonomy, like the interest to fair employment, like the interest in health. So it's this risk-based system is about the fair processing of data. And it goes back to the essential elements of accountability, which were developed in the multi-stakeholder process in 2009. So organizations are required by the Fair and Open Use Act to be accountable and to be measured. There are metrics within the law on what it means to be accountable and measured. It requires organizations to inform individuals about how the data is being used, and empowers individuals with rights. But it never requires the individuals to be the active player in governing the use of the data. That is the role of the organization. And it suggests that you need to have a more robust regulatory structure. And the last third of the Fair and Open Use Act goes to this question of what it means to have a more robust FTC. But it also sets the pattern that what the FTC is trying to look at in terms of organizations is whether they're making decisions about the use of data that are done in a competent fashion with integrity. So it's asking them not to second guess, but to rather to see whether the organization has the skill set to make decisions and the integrity to do that. And that's very similar to the regulatory structure that we see for financial services. It doesn't mean that you have a get out of jail card if you do harm to individuals. You still have to make good on that harm, but it really begins to differentiate based on what you're doing as an organization. Could you please change the slide? So the fact is that I'm going to give it back to Barb.
Yes, thank you, Marty, for the handoff. And so this slide does have a build. So Marty gave kind of the overview, how we thought about the Fair and Open Use Act. And again, just reinforcing that it is risk-based, based on accountability elements, which we're calling the fair processing principles. And what we actually did in creating this model legislation that's educational in nature is we took the core principles and we color-coded them. So if you want to do the first build, the first principle on the slide, just if we could have the slide, there we go, there we go. So as Marty said, accountable and measured. So that means being answerable. That means being responsible, which means some of the foundational things that you may or should already be doing, whether that's data inventory and data mapping and some type of PIA or other risk assessment, but it's doing that on a consistent basis. And then that's part of being answerable and responsible, and that you can explain how data is processed and the objective measures for that and what the expected outcomes are. Click next. And then informing and empowering. This is just our version of the classic, I hate to say notice and consent, because I think what we're saying is that it's not that notice and consent go away. It's just reframing that as informing and empowering individuals and not requiring individuals, all of us, to bear the burden of every single yes, no for every single possible potential use of data in an observational world. And so reinforces the idea that yes, there are proactive obligations around notices and educational information for individuals, but also other stakeholders about what's processed, how it's processed, and also how you're managing that risk, and then where there are choices or other empowering actions that can take place. Next build. And then, as Marty alluded to, we spent a lot of time thinking about what it means to have a robust enforcement approach and really building on what a competent oversight organization looks like. So taking what the FTC is today and actually building out their mission to be both enforcement and oversight, and emphasizing that enforcement activity that comes from looking at what are bad decisions and what are anomalies, and Marty alluded to that a moment ago, but that a well-resourced, we believe strongly, a well-resourced and capable regulatory enforcement mechanism is necessary. So think about this as the trade-off is for more flexibility and clear legal certainty, then that means you as an organization have more obligations, you have more burdens, but you also get more flexibility with that. So let's go to the next page. There's also a build on this one. So yes, this is an eye chart. Not expecting you to read all of this, but what we've done is actually summarize on one page what the Fair and Open Use Act looks like. So if we do a build, let's click once. There we go. So the first principle, accountable and measured. So what we've done is just highlight the sections that address that concept around accountable and measurable. And then if we click again, the blue. So the blue is that inform and empower. So you can see where we built that together. And then if you click one more time, then you see that all of the yellow, and that shows where we have the enforcement and oversight, and that component woven through the entire model legislation. So the intent is not to go deep dive into any of these topics, but to show you that these are the concepts and the principles that frames how the model legislation is structured. So if we could go to the next page, please. So I'm actually going to turn it over to Marty, and Marty's going to talk about why the risk-based model is superior, and then we'll wrap up and have time for questions.
So the fact is that this legislation is structured differently than almost any other model. You can look at all of the draft legislation from the various members of Congress, and you'll find that this does not look like any of them, yet it borrows many elements of all of them. And it is glass-breaking legislation or model legislation that is really modeled after what the world will look like in 2030, not what the world looked like in 2020. And Julie Cohen, a law professor from Washington, D.C., is pretty much said that all of the models that are on the table in Washington are just not fit for purpose. And we really tried to make this one that looks forward. But we also intend it to be interoperable with other systems. So the first, and I think the most important piece of this, is it truly empowers organizations to think with data. So the highest, most effective use of data is this whole question of being able to use data to come up with new insights. And it's those new insights that then allow you to apply the data in new ways that are both useful for your organization and useful for your stakeholders as an organization. And almost every legal system around information use has not really figured out a way to empower this concept of knowledge creation. And knowledge creation is one of 11 legitimate uses of data within the IAF model. But it's also based on the sound concept that when you're thinking with data, that creates less risk for individuals than when you act with data. So coming up with the new insight is the knowledge creation, applying it is the decision making related to that. It requires organizations to change, but the change has implementable guidelines and steps. So the legislation itself explains what it means to have levels of risk, what those levels of risk, and how you begin to model it. It does require documentation, but the documentation isn't documentation for documentation's sake. It is documentation that is intended to flow from the risk assessments that are really basic to this model. And it's that documentation that then allows a more robust regulatory system to be able to do oversight, not just enforcement. So the documentation is there, but it isn't just for the purpose of documentation. Like some of the documentation, for example, related to Schrems 2. Most of all, and I'm just going to go back to this, is what this legislation lets you do is it allows your organization to think with data, create new insights. If you think about artificial intelligence, if you think about all of advanced analytics, it's all about looking for the knowledge that's hidden in data that math can help us see, and then that you have to apply in a fair and honest fashion. So what this does, and the reason it gives greater flexibility, is it makes it possible for organizations to truly do knowledge creation and think with data. Please change the slide.
Okay, so wrapping up, as you've heard us talk about the fact that IAF is an educational organization, we're not a lobbying organization, but we will be holding a number of virtual sessions where we'll talk about different aspects of the model legislation over the next several months. We're also looking to hold an in-person event in the fall in Washington, D.C. to discuss it further and get feedback, particularly about risk-based approaches. If you'd like to learn more, please contact us. That information is actually on the next page in the resources section, which has links to, and I know that we'll be sharing the slides, so that has links to the Fair and Open Use Act. It also has links to some of our other supporting documentation that goes along with that in particular, and then how to reach us. So I know that there are a couple of couple of questions from the audience. And Virginia, could you just read that out for us real quickly, please?
Sure. So I just want to say before we get into the questions, thank you, because our next panel is Alistair McTaggart. So this is set us up for
maybe Alistair was
our
listening
keynote.
and is going, wait, no.
This is
No,
set us up
we'll chat with him
for a different mindset, as we listen to Alistair. So thank you for setting that conversation up.
Mm-hmm.
One question I have is, you mentioned that gap between the way an EU regulator might think about risk and accountability and the way a company might think about data risk and accountability. Is there a role for technology standardization, privacy standardization in the middle there somewhere, like the security sector uses to standardize across? Is there a role for standardization in this framework?
Let me answer first, and I'll give it back to Barb, who is much more into how things get operationalized. I'm a theorist. So the fact is, there has to be some creation of standards and norms for small to medium organizations, for example. I mean, this is complex legislation. We need standards created. There's room in this legislation for safe harbor positions. So the fact is that, yes, standards are necessary, but standards for this question of when is the use of data appropriate is somewhat more difficult than for things that are objective, like is data secure. So the fact is that there has to be room for standards, but it doesn't absolve organizations from doing an assessment and saying, who are the stakeholders that are going to be impacted by the use of data, and how are they going to be impacted, and how do I begin to understand the balance between those stakeholders? So yes, there's room for standards. There has to be room for standards, but at the same time, organizations are going to have to look at the context in which they're doing and begin to make decisions based on that, particularly when things are new and novel. Barb?
Yes, what I would add to that is that there are significant elements throughout the model legislation that are taken directly from the NIST framework. So one of the things that we probably didn't emphasize is that in Mark Groman doing this work for us and really building out what legislative language would look like around accountability and a risk-based approach, is Mark looked at every proposed legislation that is sitting in Congress or was proposed last year. He's looked at the majority of the state proposals and the current ones in play that we've already mentioned, as well as, of course, being very familiar with the GDPR as well. So we've actually looked at and built in components from CCPA, for example. We think we have an answer to what Virginia and Colorado are saying around conducting risk assessments, and in a way that creates more certainty around, what are the guardrails? And so we fully recognize organizations are doing assessments today. Most organizations are in one form or another that speak to standards, and they tend to be more centered on the information security side, but more and more they're certainly not exclusively information security. So whether that is the ISO 27017 or 18 standards, or SOC 2, or the NIST standards themselves. So when we think about standards, that there's a lot of the components already in the model legislation. Virginia, I know that there was another question around data minimization, and and I think it was sacrificing data minimization. And there really isn't anything in the model legislation that specifically, I would perhaps debate or want to understand better what the person means by sacrifice data minimization, because there are certainly data minimization concepts built into the risk assessment components of the model legislation. So I don't think that we've left that behind, but what we've said in the model legislation and our approach from an accountability perspective is that in an observational AI-based age, the idea that individuals will be able to or want to say yes or no or maybe to every single possible use is more than a cognitive burden. It's almost a cognitive impossibility. And we're saying it's time to be more explicit about how organizations should be more responsible and answerable. In other words, accountable, and be able to demonstrate through their risk assessments.
So data minimization comes out as a risk factor, and organizations shouldn't, and organizations shouldn't be collecting data frivolously. But think about a world where training data for AI is so important. And it's not just the volume of data that's important, it's the right data. It's data that has been vetted for its applicability and accuracy. If your major objective is minimizing the data, then that impacts the quality of the answers that come from an AI process. And that's important because that does impact discrimination. It impacts the decisions that are made. For example, there are privacy by design concepts like differential privacy, which work real well in some settings, don't work really well in a health setting when you're looking for the fourth or fifth differential. So the answer is that data minimization is a concept that goes to the risk you create for others. But the fact is that the concept, it has to be balanced against the accuracy of the decisions made when you're using the data, particularly when using the data in a fashion that has impacts on individuals. So it's not a simple yes, it's data minimization or no. It's the right data for the right application at the right time. And there's data that is necessary when you're thinking with data, when you're doing the knowledge creation, that is absolutely not applicable for the application of the data. And data minimization does come into play in that instance.
So there's a second. Wow, there's a second component to that question, Marty and Barb, and I think it has to do with thinking about a corporation or an organization setting its own risk-based standards. How do you ensure that the setting of those standards are not for personal gain or, are consistent with the accountabilities that you and I are talking about today and have in mind? That's one question. And the second question is the model legislation intended to be a replacement or is it additive to current frameworks and legislation?
So that the last part, is it additive too? I think that models are going to evolve. I believe that the GDPR, the 6 legal basis in the GDPR, need to be expanded for Europe to meet its digital objective. And so I think there is going to be evolution of all legal models. And we intend this one to be interoperable with and to help expand the way we think about some of these issues. So it is helping the evolution of processes. Key IAF concepts were applied in some of the changes that took place recently in Singapore, and you can see that connection. That's the way it meant. In terms of this whole question of, this is not intended to be a self-regulatory model, so you can't come up with your own sense of what is risk to individuals and risk and not. Remember that this concept of assessments says you have to do so with competency and integrity. And this concept that you as your organization is going to make up its own standards, going to make decisions about that, would then lead to regulators coming to the conclusion that you made your decisions without competency and integrity. So, and the fact is, this model does allow for spot checking by the regulatory agency, the FTC. It provides greater staff to the FTC and requires the FTC, and it gives the FTC the tools to actually retain the high-skilled people necessary for this type of oversight. So this is not self-regulation. Barb, is it self-regulation?
I think the era of self-regulation has passed, so no, it's not.
We can't hear you,
I don't
Jimmy.
see any more questions. If there are more questions from our audience, please queue them up in the Q&A. Taking sort of advantage of, Barb, your practical experience, can you give us some of your experience, ideas, thoughts on how, take one of the principles that would work and play out internally? So maybe take the first principle and say, what are some of the things that an organization would need to put in place that are different than what they might already have?
I think one of the things that I think is important that I give our good friends in Europe credit for is this idea of data mapping and data inventories, because before you can actually conduct a risk assessment, you need to know what data you have, where it's coming from, why you're using it. So you can think of that as a version of your records of processing. That has served California as well, and the CCPA and the CPRA as it comes up. And so when I think about then, for example, accountable and measured, so the first thing is you have to know what you have in order to measure it. That's sort of just a business fundamental. And I think sometimes what's happened in privacy over the years is we get focused on the word privacy, and really what we're talking about is the data about people. And so if you start thinking about data and what you have, this idea that data is an asset, that says it has a financial value, but we're saying it has an intrinsic value around knowledge discovery, as Marty described, knowledge creation, and ultimately being able to apply that knowledge. But I think just the fundamentals are knowing what you have and then how you're going to use it, because then that is really the input into the risk assessment process. And then I think the other thing, which again, I just want to reinforce what I mentioned before, is, it might be, you might be hearing this and thinking, oh my God, another risk assessment. How many risk assessments do I need to do? How many assessments do I need to do? And we're not saying do a dozen assessments. That's absurd. That's a different kind of burden. But what we're saying is take the information and the knowledge you have about the data you have. And if you don't have it, that's kind of the first thing, is to go back and build out and use technology. Wirewheel's actually a company that has fabulous technology that can help you understand where your data is and all of your logical and physical locations, among other things, and provides the tools for that. But when you have that, then is, what is your core risk assessment? And then what do you need to add to that we've described in the Fair and Open Use Act? So you're not necessarily starting from scratch. I would say you're building on what you already have in a way that gets you to this more answerable and responsible approach around data.
So in Canada, we see a number of organizations who've been involved in projects related to the ethical use of data, because there's a reasonable person standard that's part of Canadian law. And so they've moved from traditional PIAs, and Canadian companies have been doing PIAs for about 10 years now. They've moved to add additional questions related to who are the stakeholders that are impacted by the use of the data, and how are they doing that. And that's a simple example of what you add to your existing process. And it goes to the key issues that are part of this, which is who are the stakeholders and how are they impacted, both by the processing and not processing the data. And we already see this in some of the organizations that are looking to this question of what would a reasonable person consider reasonable, have gone to this concept of stakeholder analysis, which is built into this process.
Yeah. And I think the other thing I would even add to that is that it should not go without saying is that within an organization, there are going to be different thresholds and different stakeholders. And that can be based on function. It's going to be different if you're in product development, product engineering, if you're a chief architect, in a software company, different from if you're building hardware devices, different if you're providing financial services and solutions, different if you're in healthcare or in medical devices or in connected devices. If you're a B2B cloud provider, It's a not completely different set, in many cases, then you're answerable to your business customers, in addition to other stakeholders as well. So the beauty of the flexibility in the risk model we've identified is that it also understands and takes into account that based on your industry or your line of business or your business function, that your risk assessments will look different.
Yeah, so yesterday we had a panel led by our CEO, Justin. And one of the outcomes that I heard from the panel was the importance of that middle layer, Barb. And I think this is maybe one of the things we're talking about, that middle layer of the privacy engineer who understands the use modeling. And it really is it's no longer, from what I'm hearing from our clients, it's no longer about a static data inventory or a static asset inventory, but how data flows real time for different uses across applications and systems, and how that relates to the privacy notice you've given and who's accountable for it. Mm-hmm. So it's morphed into something that requires, this is what coming out of our panel, morphed into something, accountability is morphed into something that requires the involvement of engineering. Yes. To build in those solutions. Would you agree with that?
I would absolutely agree with that. And I think we've been talking about privacy engineering for pretty close to a decade now. But I think that as the rise of cloud, the rise of this new iteration of AI in the last few years in particular, connected devices, when we think about just all of the new capabilities that business models create. I actually don't know how you can be successful if you don't have someone who has a privacy engineering role or multiple someones. And I would even say in some organizations, that's not a middle layer, that's actually a direct peer companion to the chief privacy officer or the chief data ethics officer, because you start thinking about things like data management and data governance as a strategic piece, and then data management, the business process and the technical piece, and then the policy piece along with that. So, I see them as companions and actually really critical. I think to be successful, you need a privacy engineer or someone's who have that kind of role that can connect the policy and the process with the technology and the data.
So, and they for the engineering, privacy engineering to work, you actually have to have some key concepts that they can link to. They need to be able to hard code what are the objectives and the values of the organization. So you mentioned data mapping and not being static. The fact is the IAF model legislation defines inferred data, defines provided data, third-party provided data, inferred data, and observed data. And the fact is that inferred data is constantly generated by an organization that is thinking with data. So it can't be a static system. It has to be a system where the engineers who are and the data scientists are building a model, understanding that they're creating new data elements that need to be revealable to individuals.
Yep. No, I think that's definitely true. And I think the other thing along with that is that when we think about those kinds, just that kind of effort, that one thing we haven't mentioned is what I was thinking about was the connection also with the information security colleagues. And that they oftentimes, what I've seen more recently is sort of a interim step to a privacy engineer and being able to translate policy and process to code. Is your information security colleagues are actually critical partners on that journey. And I like to think of kind of what we talked about as there's a, just as if you're manufacturing, a smartphone, there's a supply chain. When you're creating knowledge, there's a data supply chain. And think about it that way.
All right, so we have just a few minutes left. Why don't I sort of open the floor for final comments? And, if I could ask who's ever driving the slides to maybe put that last slide up again for people who want to take a look at the framework and maybe even join in the conversation about the framework. And, please tell folks how they can do that.
Yeah, so that would be the resources page.
So Marty, final remarks?
Well, I mean, we're serious that we want to know what you're thinking. So please do let us know what you're thinking. We're going to have an in-person session in Washington in September where we're just openly in a public setting going to say risk of what? Because we think that this question of the risks we're trying to solve in an information age with legislation should actually be settled before we actually enact something into law. So for a public dialogue in September, please join us. We have, one of the things we do is every other week, we have a unscripted dialogue with the world. We call our Thursday chat. That's a place where you could join us and give us your views.
Yep. If you want to join the Thursday chat, just send something to info@informationaccountability.org, or you can send it to Marty and I. You can find our information on the website. So our website is informationaccountability.org. Surprise. And then again, the links here for Fair and Open Use Act. We've done a lot of deep thinking around what assessments look like, particularly as it incorporates artificial intelligence. As just a quick side note, we'll also be providing comments to the proposed AI regulation out of Europe. We're actively working on that right now. So again, we encourage your questions, your engagements, your thoughts. We'd love your feedback, so please reach out.